I have two videos going on, so there may be a echo, but I'll be brief. Let's see here. You guys able to see my screen?
Yes.
Okay. Not me, but the actual presentation.
Yes.
Not me. Okay. Well, I'll operate without the shared screen.
And you're good, Sherry. We're seeing your screen now.
Yeah, you're seeing it, but it's not allowing me to maneuver between the slides. So with that said, as you know, Mike, I embrace adversity to help individuals to press forward through. So with that said, welcome to I Have a Dream, part 2. And we're going to talk about some of the common issues that are faced after filing your provisional patent application or patent application. And it's brought to you by the USPTO Midwest Regional Office. And for those of you who are affected by the pandemic, this is an excellent session for you so that you can identify which method to go about applying for IP yourself. So I'm going to cut this short and turn it over to Tim Spear, who is a USPTO supervisory patent reexamination
It's a
specialist.
mouthful. It's a whole mouthful, really.
There you go.
PTO manager's enough.
My echo here. Take it over, Tim.
Okay, and just one thing for you. What time? How late? This is supposed to go until 5:30. Is that correct?
Yes. If
Okay, so we have about
we have
45
enough
minutes.
questions
Well,
but
I
I'm
have
thinking
55 slides, so we're going to get through a lot of these fast. We'll be condensing a lot of things. Some of them are, I think, in a bit more detail than what we really need.
Okay.
For here. So let me share my screen and we'll get started. So this is going to be, are we good to go there? Do you see it?
Looks great, Tim.
Okay, great. So this is going to be here. We're going to talk. This is going to be sort of a couple of things. Our objectives are going to be, we're going to talk about some of the basics of patents. We're going to talk about what the filing requirements are when you get ready to file your application, some common mistakes we see. What's the procedure? I file my application and then what happens? And then we're going to talk again about some other resources that the office has available. So patent basics, the constitutional authority. So when this country was founded, patent issues had been an issue in Britain. There were certain types of patents that were available there, offered, I believe, through the Crown. But people were, you know, they saw the value of intellectual property in this country enough to enshrine it in Article 1, Section 8, Clause 3 of the Constitution, which gives the government, in order to promote progress in science and the useful arts, the sciences, the industrial things, by securing for limited times authors and inventors. So this gives us copyrights and trade and patent protection here in Article 1. So we're in the executive branch, which is the Article 1. And so what is a patent? A patent is a property right But unlike many property rights, if I buy a house, if I buy something, I have that thing and that's the right I have. What a patent gives you is the right to exclude others from doing something. You exclude others from making, using, selling, or offering for sale that which you have claimed in your patent. And so that's the force in the use of a patent, is this exclusionary right, an exclusionary monopoly. For a limited term, 20 years from, we'll call it the date that the application was, the application was filed, and also they're territorial, so there's no worldwide patent. We get them by country, and you can apply in various countries across the world. That's beyond the scope of what we want to talk about. And again, please, if you have any questions, please put them in the chat and someone bring them up to my attention if you can, because I'd like to make this as interactive as we can. A lot of this is very detailed about specific requirements or filing and stuff, and I'm going to kind of skip over a lot of that. Not that it's not important, but we can find that in other places, and we'll tell you where to get that. So why get a patent? Well, you know, Abraham Lincoln said the patent system adds the fire of interest to the genius, the fuel of interest to the fire of genius, and the genius being you, the inventors. And that by giving those rights, you know, to people and preserving that, there's real value to that. And it can help promote innovation, and it can help you protect, you know, in a real meaningful way that which you've created, so you can benefit from that. It can help companies grow, and that can be used to in various ways, can be used to show, you know, folks that who want to maybe invest in you, they can review your patent portfolio, and maybe that's of economic value. You can use it for that. For the community, we encourage to promote progress, making new goods, new things available, continuously, you know, helping the economy. The patent system has done that from the very beginning and continues to do that here. And additionally, personal growth, development, and, you know, and personal advancement for people who invent and like to do that sort of thing. You know, it's great to have your rights protected. So we do have several types of patents. We're going to focus here on utility patents. They're directed to basically things and methods of using things and making things, new and useful processes, machines, articles of manufacture, compositions of matter, and improvements on them. So as James mentioned earlier, we talked about provisional and non-provisional, and we'll touch on those again a little later. Provisional applications are filed, and they expire 1 year from the date of filing as a matter of law. So you can file a non-provisional application that claims priority to that, and then that non-provisional application will be examined and can actually result in the issuance of a patent. Additionally, we have design patents. They're directed to ornaments for articles of manufacture. These are important as well. There was recently a big case involving Apple and Samsung over the design of cell phones. That was a big battle over design patents, and they were at the center of that. We additionally have plant patents. These are for asexually produced plants. I don't know if we have any plant folks in the crowd today, but those are available as well. So provisional versus non-provisional, James had talked about some of this stuff before, so I think we'll just touch on it again. Provisional applications are not examined, they're never published. They have a 1 year time limit. If you do not file a non-provisional application, which claims what we call claiming priority to that provisional application, that patent expires. They're available for both utility and planned applications. And so basically what it gets you is what we call an effective filing date. That's useful for a number of reasons when we get to the examination process and we look at your claims and we're deciding what prior art's the things that other people have done, their patent publications, all sorts of non-patent literature. That's what we call the prior art. The portion of that which we can sort of use against your claims to try to figure out whether or not you can give a patent will be impacted by what your effective filing date is. And the provisional application gets you an earlier effective filing date. As opposed to non-provisional applications, these are reviewed for formal matters by the office, and then they're sent to be examined. After 18 months, they're published, unless you make a request for non-publication. If you do that, I believe you're then stopped from filing applications for this subject matter in other countries. These can then mature into a patent depending on how the process goes, and your patent protection, the term of the patent is going to be set by when the first non-provisional application is filed. So the benefits of the provisional application, and again, I want to check I made some notes here so I could make sure I addressed everything I wanted to. So this gives you time to investigate market potential and see maybe how this is going to go. But there's a fine line here between testing and marketing and public disclosures. There are things you can do if you disclose your invention in public and then you don't file an application within a year, or you offer it for sale. Those can be bars to a patent down the road. So when you talk about investigating the market, you do need to be careful to some extent, the way you do that. And that's something that you need to look into as you do that going forward with your invention. You can file multiple provisional applications during that 1 year. So basically what they're talking about here is you file a first provisional application containing a bunch of subject matter. You have some other things that you've come up with that are some additions to that you want to add. You file another provisional application. And then within 1 year from filing the first application, you take all of that, you mash it together, and you put it in one utility application, a non-provisional, right? And then you get some of the claim, then all of that can be used in what's called your priority data. And I don't want to get into too much about the specifics of that. You can also use this time, if you want to talk to attorneys, obtain counsel, someone to represent you. It is a very complicated process to go through, and it's technical and it's legal. You can do it by yourself, but we of course do advise, if possible, to get an attorney to help you through the process. And patent term is measured from the filing date of the first non-provisional application that's filed. As to the term patent pending, you can use that as soon as you file your provisional application. However, if the 1 year elapses and you don't file a non-provisional application, you would have to stop using that because you no longer have a patent application pending before the office. And so you no longer have a patent pending, right? So if you don't file that utility application, you wouldn't be able to continue using that in your marketing efforts. So this is just a general roadmap about what happens when we file an application, okay? So the application is filed, and then it goes through this process. They show by these rollers of the application is given to an examiner. The examiner reviews the application and any other materials submitted by you, the applicant. The examiner does an independent search of what we call the prior art. The examiner looks at all these things together, looks at your claims, all of your disclosure, comes up with some findings about the adequacy of that. Some of those things are called rejections. Some of those things are called objections. We write something up. We send that out to you. You respond based on what we did, and you can amend your claims, and you have certain actions you can take at that point. You send us a response in, and we look at that and evaluate again in view of any evidence or anything that you've submitted. We reconsider our position, and then we either can send out another action. We could allow your case and issue your patent, or in some instances, we simply can't come to agreement and your application goes abandoned and you don't get an application, right? So the application can go abandoned. You can get it allowed. You can also file an appeal of the examiner's decision. That still will ultimately lead either to an abandonment or an allowance. The appeal is taken first to, we have some judges in the patent office that you appeal to the Board of Patent Appeals and Interferences, Patent Trial Appeal Board, I'm sorry, we've changed the name over the years. I forget. And then you can appeal to the Court of Appeals for the Federal Circuit if you have issues with that. So that ultimately leads back to us, though, and at the end of all that proceeding, we either abandon your case or reissue it, or you could refile it. But in the end, those things happen. Typical processing time, again, this is based, this is from fiscal year 2019. So the whole process typically takes a little over, we have 25 months here. It's really somewhat art specific. Some areas move faster than others. And then here is something that's going to be really useful for you guys, just to get a look at the patent and think about what they are, kind of get familiar with it. This is like James talked about. If you can search and find some patents in your art area, look at them, kind of see what they look like. And here we have the patent number here. I'm sorry, you can't see it a little better, but basically the front of here, we have an abstract, and we have what we would call the written description, which is the specification. We're going to get into more of the parts of that in a little bit. The specification supports what are called the claims. The claims, once they issue, are the part of the patent that define the subject matter of your legal protection. The description must do these things. It has to tell us how your invention works, and it has to tell us how to make the invention. And additionally, actually, it has to you have to tell us the best way you know to do that. If you've done testing and you find, for instance, it's a process of making something, you find some reactant to be particularly better than others, you need to disclose that. That is statutorily provided. You know, the way the patent system works, the patent system is set forth in the Constitution. And then the Congress enacts Title 35 USC, are the patent laws, which are enacted by Congress. And then so they're the Article 2, the legislative branch. And then we in the executive branch, they create what we call 37 CFR, the Code of Federal Regulations, and those are the patent rules. So the patent laws, 35 USC, and you'll see that as you look through things, are laws that were passed by Congress. 37 CFR are rules that the office enacts in order, or develops in order to enact those laws, right, to enforce those laws. So that's what we're doing here at the patent office. So you'll see those two things, 35 USC and 37 CFR. That's all of the authority that we have and where everything comes from. The drawings can be included if you think they're necessary for your invention. And then of course the claims which define the legal boundaries. So let's go through refiling requirements. And please, if anyone has any questions, jump in and ask. I'd be happy to take any questions if anyone has anything. So when you file this, we're talking about, excuse me? I thought I heard someone asking a question. So we're talking here about filing the utility application. And these are the parts that you need to have. Your specification, which you talked about again, which describes the invention, and you need to have at least one claim, right? The way it's been set up is your filing fee includes, as we said earlier, 20 claims, a maximum of 20 claims, with 3 being independent. If you go above that, in either way, we give you some additional charges. You can file as many as you want. We will take as much money as you want to give us. But there are filing fees for the claim number. So that's something to keep in mind as you go through the process. You also include the inventor information here, your residence mailing addresses, all the sort of contact information. There'll be an oath, there's an oath or declaration. We have something now called an application data sheet. That's a sheet with it lists the inventors, it lists the applicants, it lists all of that sort of technical information. And then it also lists, you can file an application and claim priority. It's called claiming priority, or like we file the provisional application, the non-provisional application claims priority to the provisional application, right? And similarly, you can file, say you filed an application in Japan, you can file the application, an application in the United States and claim priority to that Japanese application, right? That's sort of the equivalent. I'm sorry.
Yeah, I was just gonna say, in other words, what Tim is mentioning is that you have to, when you register for a utility patent, you have to associate your provisional patent with the utility patent. It's not done automatically. And a lot of pro se inventors assume that it's automatically in the system and they know what they're talking about, and that's not the case.
You tell us to do that when you file your utility non-provisional application. And so that's included in the ADS. And when you get to these filing parts, again, we have people available. You can get information to help do that. But it is important when with anything, when you're coming before any agency, we do like a form to be filled out correctly. Let me just say that. Okay.
What happens when they don't? What if that's overlooked? And
we're going to get to that. We're going to get to that. We of course that happens. People, these things happen. But if possible, minimize that. And it's important for all of us, for you and for the office, you know, it's like with anything else, good stuff in, good stuff out, right? Be as
Okay.
thorough, as complete as you can at the beginning, and it tends to make the process easier for everyone, right? So, and then of course there are filing fees that are associated with all of these things. I don't know that we need to get into the specifics of all of that. Here for the late submissions, if you filed an application that's incomplete, we're going to talk about this. We have a part of the office that looks at the applications initially, the Office of Patent, OPAP, and I'm going to get to the acronym here in a minute. And they look at sort of these we call these sort of formal requirements for filing the application, right? You need to have a this, you need to have a that, you need to have an oath, a thing. They look at it. If you don't have all those things, they'll send you what we call a notice to file missing parts, and then we'll charge you an extra fee, but you'll have time to file that. So this is the Office of Patent Application Processing. When you first file your application, it goes to these folks, okay? And they look at it, and they do all these formal checks, and they make sure all these things are done. If there are deficiencies, they contact you, and then those things are resolved, okay? Once those things are resolved, then the application goes to a patent examiner for examination and for further review, okay? This is just a sample notice of missing parts. You'll get a notification. It'll give you the mailing date here. It'll have probably an application number. It'll give you the time period in which you have to respond. Here you have 2 months to do this. And then it'll also, they don't show the rest of the form, but it'll tell you what the deficiencies are. You need to include a declaration. You need to include whatever's missing, whatever needs to be done. And they'll tell you on this form, they give you 2 months to do that. And you need to really try to do that within that 2 months. If you don't do it within 2 months, you know, you can still do it. There'll of course be an extra fee, and the longer you wait past that 2 months, the bigger that fee will be. But, you know, try to do it within the 2 months. We're going to go through some common mistakes that people see in filing. These are just general things. These are the big things. They're general, but they're also sort of just the formal matters of how we do this. And this is going to speak to when you get ready to the point where you think you're ready to prepare, you know, the application, even the provisional. It's important to keep these things in mind at that point, because if you do your provisional application to the extent that you can in this same sort of format, even though you don't need a claim, it makes the process of converting it to a non-provisional application that much easier down the road, right? And we can avoid some of these mistakes if we do some of the work up front. So these things are the formatting of the specification. There are rules, again, in 37 CFR, which talk about this idea, the way you number claims. We're going to go through more of it, the way font you use, the spacing, all these sorts of things have requirements. Same with the drawings, the application data sheet, signing, and then we're going to also talk about what's called the micro entity status. For very small companies and inventors, we have micro entity status, which basically you get very reduced fees before the office. So the format for the spec, and again, I don't want to spend a lot of time getting into all the details. There's a lot more slides, and I do want to encourage anyone to ask questions, but it needs to be 1.5 or double spaced. You have to have, it's just a single column. You know, all of these things we have here. Margins are, you know, these things are most times we get things now, everything is submitted electronically. We have something called the electronic filing system, and people submit most applications these days electronically. So you will format all this stuff that way. You know, you have to number the pages consecutively. You know, you can't, there are requirements on font, all that sort of stuff. Once you get ready to prepare this, you know, you're actually writing the application, you'll want to look into these things. All this stuff is on our website. You could come to us in Detroit, you could give us a call, and we can give you information about that, about what the formal requirements are. So the parts of the specification, and this is what we saw sort of when we looked at the patent, is you have the title of the invention, there are limits on that, the number of characters, I don't remember how many it is, 500, I don't remember how many characters, something about the title of the invention, the sections. Then you typically have the sections of a specification. One thing, you'll first start off and you'll tell us a little about the background of the invention. You'll tell us maybe what other people did and sort of, you know, how you came to invent what you did. Then you're going to tell us what your invention is. And you're going to start describing that. Usually the summary is just that. It's more brief. And then we go into a description of the drawings. If there are any, you'll describe all of those. You'll talk about them briefly in the brief description. And then we get into the meat of the specification, which is the detailed description. And there you're really going to set for all of the embodiments of your invention in much more detail. Everything you specifically want covered. You'll describe the claim or the drawings and all of the numbers and all the elements of the drawings in much more detail here, and you relate that to the overall invention. Okay, and then you'll additionally, so that's the specification. Technically, the claims aren't a part of the specification, they're the claims, but you will also require claims when you file a utility application, and you do have to file an abstract. It has to be less than 150 words, has to be a single paragraph. It's actually it's not supposed to use legal jargon either, legal terms. Sometimes we get to the point where, for various reasons, you need to file a substitute specification. This does not happen that often, but it's something worth touching on here, I guess. When you do such a thing, there are specific requirements for filing substitute specifications. Sometimes we get things that have been filed that are translation of foreign documents or something, or there's some reason it doesn't, it's very difficult to follow, the formatting wasn't good, and they want to file a substitute specification. And that's fine, you can do that, but we need to make sure this can impact the examination process, because you're not allowed, once you file an application, to add anything to that application at that point by amendment. We'll just say that generally, without filing a new application, let's say. You can't, in the same application, add anything. So when you do a substitute specification, we require you to provide us with two things. You have to give us a marked up copy showing all the changes relative to the previous specification. So say for the one you filed, then you have a clean copy. So when we publish the patent, we have a clean copy to work from. And then you have to sign a statement which says it contains no new matter. So new matter is a legal concept, and it means you can't add anything to the specification that wasn't already there. You can't add new disclosure. We can sort of think of that as new matter. Okay, and again, the entire thing has to be marked up, not just the amended portion. They're talking here more about how you do this. These are, again, are very formal requirements about how you add text and how you delete text with strike throughs or underlining. Again, if you get to that, it's a little weedy, I think, for what we want to talk about here. And then let's go to the drawings. So then we have the specification, we have the claims, which is going to set forth our invention, and then we have the drawings. The drawings can be very, very important, particularly in mechanical type cases. Depending in the art that you're, whatever art space you're working in, you may not have drawings. People who do a lot of electrical stuff sometimes don't have drawings. A lot of the chemical stuff, depending what it is, won't have drawings, or they'll just be flow charts showing the steps of a process or something like that. But I would probably say the vast majority actually do have drawings, and they're required, if it's necessary, to understand the subject matter to be patented. That's typically something left up to the patent owner. And, if you need drawings, you will file them, because what you do is people, and especially in certain arts, will set forth different embodiments and different drawings. And then when you write your claims, you can refer to specific drawings that capture most of the subject matter that you wanted to have covered in the claims. These are the specific requirements for drawings. They have to be black and white. Numbers have to be heavy enough to permit adequate reproduction. We have all these requirements, reference characters. If you use a reference character in a drawing, it has to be discussed and described in the specification. You have to label them, and you have to have a corresponding description in the brief description of the figures. Typically, they contain little text, although as we've got to the point where people are doing a lot of the data stuff and a lot of those algorithms, I think we're seeing a lot of stuff where there really is more written stuff, because these are just flow charts, algorithms. They're describing how things are being done. They need to be numbered consecutively, free of erasures, all that sort of stuff. And when you get ready to file the drawings in your application, you'll be looking into all of that. And again, the Office of Patent Application, Processing, review those initially as well. I don't think these days we're really reviewing them too much. Back when I started at the office, drawings were a very big deal. Nothing was electronic. We actually you had to submit copies, and we had draftsmen who reviewed them, and there were a lot of formal requirements. These days, because of these, I think that we could recreate drawings. It's not sort of the same focus as we had. But there still are these requirements. OPAP will look at them. The examiner will also look at the drawings. And in the office action that we talked about earlier, if there are issues with the drawings, the examiner will set those forth, and you will have an opportunity to correct them, to respond to them. This is the method for making amendments to drawings. You submit a new sheet, you label it in this way, and you also give a marked up copy optionally, unless the examiner asks for one. So, and that would be called an annotated sheet. And again, these need to be labeled specifically. It may seem odd, but the point is we have a lot of applications, and we get ready to issue patents. We need to know what we're supposed to publish, right? So we know that the replacement sheet or the new sheet would be published and not the annotated sheet. The application data sheet is, as we touched on earlier, is a requirement, and this is a very important element of the application papers. And this really sets forth all of the information about the inventors, about the applicant, whether or not they're joint inventors, and all these sorts of things. That's separate from the oath or declaration. That needs to be filed separately, but this also needs to be set forth in the application data sheet. And again, we mentioned priority down here. They mentioned it again here. Foreign priority claims are set forth in there. Additionally, claims to provisional applications. And once you file a first utility application, depending what happens during the examination process, you may split that out. You may file additional applications which claim priority back to that application. And those would be set forth in an application data sheet as well. So some hints about the ADS that they brought up here. They mentioned domestic benefit again, making sure that you include your domestic benefit claims and international. They're broken out into international and domestic, I believe, as I recall, benefits in your ADS, and it must be signed. They talk about here again by a registered practitioner. And again, if it's not done correctly, you'll be getting a notice to file missing parts and have an opportunity to help those things. Filing by reference, and typographical errors, avoid typographical errors when you file that information. So you will get back, once you filed your application, you'll get, this is an example of what's called a filing receipt. And I don't think I can make this any bigger, unfortunately. Can I? Just to blow it up a little bit. So this sets forth a lot of information when you get your filing receipt. It tells us who are listed as the inventors, tells us who the applicant, because sometimes the inventors don't have to be the applicants. They can have given their rights in their invention to a company, and the company can file the application on their behalf. It'll tell you whether or not a power of attorney has been appointed. If there is, that's the person that the patent office will correspond with and conduct the examination with. And then you have your priority claimed here. This is domestic priority. This would be claiming, for instance, here we're claiming priority to, this is a provisional application. You can tell by these first two digits, 61. So that's a provisional application. And then there's a place that tells if you claim priority to any foreign patent applications. And here there are none. And they also give you your application number, which is here at the bottom. And it'll tell you about what's your fee status here. They are not a micro entity. And that'll be on your filing receipt when you get that back from us. So, okay, let me see. So updating the ADS, again, there are very specific requirements for the way in which you change the application data sheet. what you do is you provide a marked up copy, and there's a specific way that you do this. You file a corrected ADS, and it shows here, changes must be shown by underlining insertions and strike through or brackets for deletions. So if you're changing things, you're adding inventors, you're changing the title, you're changing your claims for priority, you do them in this way. That way it's clear to anyone coming later on and reviewing what we call the file history. The file history is everything related to that application. And we create, once you file your application, all the other papers that are added, anything that is part of that is kept together in what we call the file history. It can be consulted later on when people are going back and reviewing the patent for instance, for infringement or for some other considerations. So that, again, this is the formal matter for doing that. And, again, once you get into the process, there'll be a lot, you'll have a lot more help with that. And here is an example of how that's done. They're adding a claim to this provisional application. So they've underlined claims benefit of, they've underlined the application number, and they've underlined the filing date of that application. So, and again, here they point out that the underlining shows that it's being added and shown that it's relative to the information shown on the filing receipt. So that also the information on the filing receipt will reflect what's in the application data sheet. So if you make changes, you also have to get a new filing receipt. And again, that's a formal matter that will be addressed when you get more into the process. The requirement for signatures are here. People are rarely, you can, as long as you do one of these formats, we're fine with it. Typically, if you have multiple inventors here, all inventors must sign, and there are limited circumstances in which that doesn't have to happen. But typically, they don't have to sign the same declaration. They can sign different declarations. Sometimes you'll have 3 inventors. They'll submit 3 different declarations, but all of them, each one signed by a different inventor, and that's acceptable. So this idea of micro-entity status, this is a program that's available. The office provides fee scales based on the size of the applicant, basically. The micro-entity status is the smallest. Patent fees are reduced by about 75% compared to what we call the large entity applicants, who are, Pfizer and Monsanto and whoever else, the big companies. The requirements for microentity status are specific as to, these requirements. The inventor, you can't be named on more than 4 previously filed non-provisional applications. There are issues as to the gross income exceeding 3 times the median household. That's going to change, of course, yearly, and I don't recall what that is at this point. And you can't have assigned any of this to someone else with respect to those requirements in number 4. And again, it mostly goes to, they're looking for people who don't have a lot of money, aren't making a lot of money off these inventions, are small companies. So that's something you'll want to see if you'll avail yourself. You can avail yourself of as possible. Again, there's a form for that, as always. So you're going to fill out the form. You're going to make sure all the information is filled out correctly. And then each applicant must submit a separate form. So you'll file for that. Again, when we get to the filing process, when you have questions about this, contact the PTO, contact an attorney, and get additional information about that. I'm sorry, was there anything in the chat that I missed? No. I think we're okay.
Nothing in the chat, Tim. Everything has been great so far.
Okay, good. Thank you.
And Tim, I'm going to have a number of questions for you in general that inventors have had over the year.
Okay, well, let me ask you this. We're supposed to wrap this up in about 10 minutes, right?
Oh, this is until 6 p.m.
Oh, so how long do we have? 40 minutes?
Yes.
Oh, so it's 7 o'clock my time. Okay. I thought we were getting real close to it because I have another chunk of slides, but we'll be done soon and then we can go to questions if you want. Is that okay?
And don't you feel rushed, because it's more important to have your valuable information than me. So
my only question to you is, do you really want to go into this really specific stuff of like the manner of making amendments and the strike through and all that? I'm trying.
That's the only way they're going to get this information. Okay. Absolutely. Absolutely.
Okay, good. And I think we're kind of getting to the point here where we are getting closer to the end of this presentation. So these are a bunch of the resources we have available. And you really should, avail yourself of these things. We have them for, how to complete the application data sheet. We have the instructions for doing that. We have, this guideline for filing non-provisional applications. And we have articles about common pitfalls, going through the process. Additionally, if you go to our website, we have hotlines available for pro se applicants or anyone else who just wants information. And as Sherry had mentioned, you can call and you will get a live person and they will help you through the process and try to direct you to the person wherever you need to go to get that question answered. And I think we do a pretty good job of that. So, think about that when you're going through the process yourself, because I know it can seem really daunting at times. So we're going to talk about now post-filing procedures. So we filed the application. It's gone through so now we're going to talk about office action. It's gone through the initial review. All the formal matters are required. All the parts of the application have been filed. And now we're going to go and we're going to get an office action. So what is an office action? Okay. This is what we talked about earlier, where this sets forth all the bases for any objections, rejections, or any action taken by the examiner. Now, when an examiner first picks up an application, there are two things we'll just generally say there are two things. They can either send out an office action, which would either reject the claims, which would reject the claims, or they can allow the case. And we would call that a first action allowance. There's some other things they can restrict. There's lots of other formal requirements, but at the basis, you'll either get an office action or you'll get an allowance when it's first filed. In the examiner's role, it's talking about these are the things that the examiners do. So the examiner should read and understand the application. The examiner conducts an independent search of the prior art. Now, one of the other things you have to do when you file the application is you have a duty when you file an application with the patent office to provide us any information you think is material to patentability. So if you know of references, if you know of disclosures that are relevant, that talk about things related to your invention, you have a duty to disclose them to us. We then do an independent prior art search of patents, printed publications, any other disclosures. And these days, there's a lot of information available. When I started the office in '92, we searched by hand. You look through printed copies of the patents, and that's pretty much the way we search. That certainly has changed a lot. The search is dependent partly on the effective filing date, which goes back to why a provisional application can be important, because the provisional application can give us an earlier effective filing date for our claims. And that can affect the prior art that's going to be available against us during this examination process. Okay. The examiner also evaluates the specification, the claims for the requirements of these 35 USC, these requirements. These are the congressionally, enacted laws about 112, which is sort of goes to the adequacy of the disclosure. Have you taught how to make it and use it in the best mode? 102 and 103 go to prior art and talk about 102 is the invention anticipated? That is the same thing has been done in the prior art, or is it obvious over things that have been done in the prior art? 35 USC 101 is directed to patentable subject matter. There are some things for which you cannot get a patent. Certain methods of organizing human behavior, human activity, mathematical and abstract mathematical ideas and abstract expressions. There's case law about all of that. That's actually an interesting point right now, that in the advent of all the tech stuff has become an issue about what is patentable and what is not patentable. We had the same thing sort of stuff years ago in the 90s, late 80s, early 90s, when a lot of the genetic stuff was getting going, and we were faced with the one big question is, what do we do about, genetically created man-made organisms? It started with bacteria. There was a case that addressed, called Chakrabarty, that directed the first microorganisms that were created, organisms that were genetically modified, and could you own that? It's developed through that. We have issues now with things like sending. There were this idea of transient signals. If we're processing things, we're sending signals through the air. I use an algorithm, I create a signal and I send it. Can I own that signal as it's transmitted, as it goes through the air? That's been one of the issues about 101. Again, it's probably a bit in the weeds for this, but that's an interesting area. The examiner considers that. And then also holding interviews to talk with this can happen after the office action has gone out, to try to talk to the applicant about the office action. So the role, these are the things the examiner does. And the role of the examiner is to work with the applicant to arrive at allowable subject matter, to find something that in their disclosure where we can amend the claims in a way that the examiner agrees the claims are free of the prior art, and the applicant is willing to take that scope, that claim coverage. And so to me, the role of the examiner is to work with the applicant to arrive at allowable subject matter. We do that by doing these things, in setting out the office action and starting that conversation. Interviews can be very, very useful. Very few here we see, most applications are rejected, up front. 16% in 2019 were allowed on first action. That seems pretty high to me, quite frankly. When I worked at the law firm, they would say, if you got a case allowed on first action, your claims were too narrow because you should have given them broader claims and let them apply prior art and then try to narrow it down. So that's interesting to me. That's such a high percentage. But do not despair, of course. Once you get the action from the office, you have a number of things you can do. You can start amending your claims. And this is where we get into, the prior art becomes very important. And then we start changing the claim language, and we see if we can somehow carve out something that isn't touched by that prior art, and we can give you your patent. There's other evidence you can come in. There are lots of ways that you can respond to those rejections. So again, they're a normal part of the process, and they help us define what's patentable. We can focus here on, there are many types of, not many types, but there are rejections unrelated to prior art that go to sort of what we call, examiners refer to as the definiteness of the claims, whether they set forth the claims, sufficiently clearly that you could readily determine the scope of the claims. If I wanted to do something, can I look at your patent and say, gosh, what do these claims mean? If the examiner thinks that can't be done, they can reject your claims on that basis, and they can also reject the claims based on prior art and what they find. You then, of course, have an opportunity to respond, and there are actions you can take to overcome or to argue all of these issues that are raised by the examiner. And a very useful tool, and I would encourage people to do this, is to have interviews if you can. Once you've received a first action, it can be very, very useful to sit down and talk in person with the examiner. In any areas, just writing back and forth is not always the best way to communicate. You have one person setting their position forth in a very rigid sort of manner, and then a response, but there can be no, compromise. So the interview allows the opportunity for you to get together with the examiner, talk about the case, talk about the issues, and see if you can find a way forward to overcome the rejections and whatever the issues are that are standing in the way of issuance. So
has this always, I'm even surprised by this. Has this always been available, the interview, and who sets up the interview?
Yes.
Oh, didn't know
anyone can, either the attorney or the applicant or the examiners can call applicants. We do that all the time. Like, I'm examining a case, you've given me some kind of claim, and I think, you know what, that claim would be patentable if it also just said this one other thing, right? So I call you and I say, hey, will you add this? And then I'll issue your claim, right? And that could be an interview, and you may agree with me, you may not, and that's fine, that's up to you, but that's an interview. Typically what we have is the applicant, once they get the office action, will contact the examiner and request an interview because they want to talk about the office action prior to filing their response, right? That's the really useful time, right? Talk to us before you file your response. If you've already filed your response, we're probably not going to give you an interview, right? Because you've already filed your response, right?
Okay.
Right. So that's when they're most useful. Interviews from the applicant's perspective should be, you've gotten the office action, we want clarification. The examiners raise these points. We want to come in and talk about, They can make legal arguments. They can make technical arguments about the science or, behind whatever is being addressed to the prior art. And you can hash those out sometimes beforehand. They can come into the interview, and sometimes they'll come in with proposed amendments where you can talk about, okay, you didn't think these claims were okay. How about these other amended claims? And we can kind of work through that with them. And that can be very useful as well.
So those discussions are that in depth? I mean, they're willing to give you that type of time? And are they all video conferences, phone conferences, or what?
Okay, so James mentioned the MPEP. I don't know, the Manual of Patent Examining Procedure is the the guidebook of how we examine. All of this stuff is set forth in 37 CFR. There are rules about interviews, and they're typically limited to 30 minutes. The examiner has the discretion to grant them basically.
Wow.
We can always have them if we want. I work in the area I work in. I don't actually examine utility applications. My work group, we do what are called post-grant reviews. You can file for issued patents. You can do what's called a reissue or a re-examination. And we look at those things. Re-examinations can be, so in that case, we find it very, very useful. And they're often, they'll come in with presentations. We will make your presentation of record. If you give me a paper and you say, here's some proposed amendments, I will enter that into the file when I do, because there's an interview summary record that's prepared by the examiner. And there's also one that's prepared by the applicant, memorializing what we talked about, but we'll put that in the record. Now, we may not agree, but oftentimes we do agree, and it's really a good place to find a way forward.
Tim, this slide should be on your website. So because I can't imagine any pro se applicant not wanting to take advantage of this. So
right.
just
interviews are very, very important. And I think, it's something you should remind as you go out and you speak to people about these matters. Keep this in mind. And all of you who are here, remember when you're before the office, and you can always, and you have an applicant, one point I want to point out. The office doesn't do double, what we call double correspondence. So if you're represented by a patent attorney, don't call you individually, don't call the office. We will only correspond with your representative, right?
Gotcha.
We won't, if you have an attorney, don't call us on your own and say, I don't think my attorney's doing this right or doing, no. That's not our area. Okay, we only correspond with whoever's a record. If you're a pro se operator, certainly call us. We'll be happy to talk to you. We do even have a pro se art unit. We do, we understand the difficulties. We have resources available, which we'll get to later, that are available to help pro se applicants. Okay. So again, I'm glad we talked about that for a long time. I really think interviews can be very, very important, very useful. I have found them personally over the years, from my practice that they are. So now we'll talk about after final practice, and to talk about this, we have to talk about types of rejections. Okay, so normally what you do is you file your application and we send out what we would call a first office action on the merits. Okay, and that's what we call a non-final application or a rejection. And you have an opportunity to respond to that in a number of ways. And you have a wide range of ways that you're entitled to respond as a matter of law and as a matter of right. After you've responded to one, depending what happens, we can issue what's called a final rejection. And once we're after final, your options are more limited. You can appeal your case. You can say the examiner is wrong, and you can file an appeal to the Patent Trial and Appeal Board. You can do that anytime after the claims have been twice rejected. You don't even have to wait for a final rejection. You can file what's called a request for continued examination, where the examination would continue. The finality basically is removed, and you get another action, which could be a final or a non-final, depending on what happened there. You can also file a response, but you have limited rights about what you're allowed to present. You can submit a response, and the office will consider that. And based on those parameters, it can allow your case. It can deny entry of that, which happens often. And those are your things after final, basically. So that's something when you get to the final, you will then have to talk with whoever's representing you or make some determinations about what you want for your path forward. And let's talk about a happy thing that are allowances. So allowances, once a case is allowed, all objections, rejections, all formal matters, and all other statutory and legal matters have been addressed, and the application is ready for issuance. I'm not sure what that number is supposed to be. Fiscal year 20, I'm thinking that's supposed to be, I'm not sure where the 9 came from. So there's some 60% what we call allowances by examiners. Examiners get counts, what are called counts. We measure production there. We have to have a way to measure the work that we do. And part of what we do is we look at how many cases examiners issue, and you get certain credit for that. 58% of those are allowances. We're going to now move into some more about resources. Did you have anything else, Sherry, you wanted to talk about there? We're going to move into resources now, or anyone else, if you want to jump in, please do.
Absolutely. Well, I have some general questions about some of the things that you've covered already.
Okay.
When we talk about the application process, as far as drawings in black and white, a lot of the pro se applicants don't realize the fine print that says it must be in black and white. And that means that it can't even include the shading. And then so my question to you is, how does your office respond? What's a typical response from your office for those incorrect drawings, especially when individuals send in pictures and think that they can just upload a color picture and label it? How do you respond?
Well, you can okay, well, there is a process. I believe you have to petition to file color photographs. There's certain instances that's very limited where you can file color photographs. I believe as to the issue of whether or not they're colored, I think that might be taken care of by OPAP, and that would be addressed by them, but I'm not sure if that or if the examiner, someone during the examination process would tell you, you need to submit new drawings and they can't be in color, and this is what you need to do. And we'll tell you how to correct that, right? But it will be raised as an issue during the process.
And how should they expect to receive correspondence? Is it via mail? Is it via email? Or is it on their USPTO? What do you guys refer to our individual accounts?
Private pair. So, right, I was going to touch on, we have something called private pair, which, and I hate to say this, I'm not sure I can really speak to this that well. I think we still mail things out in paper, but I'm not sure if you can opt out of that. I don't deal with that part of the process very much.
Office actions generally are sent via email.
In the old days, everything was sent by mail. U.S. Postal Service, everything went out in paper. And I believe we still are sending paper copies. And if anyone else is here from the office that could confirm that for me or correct that for me, please do. And if not, I'll get back to you about that, because I'm not exactly sure how we do have something now called public pair. And I'll tell you what most people do, even if we are mailing out, they check public pair or private pair. Once you file an application, you can set up an electronic account. It'll give you access to your application, all of the materials, all of the papers, everything there. They'll be available really instantaneously. Once we mail them, they'll show up there and you'll be able to have access before it even arrives in your mailbox. So that's very useful. And I wanted to bring up, and I'm glad you brought up pair. There's also something available called public pair. And if you find information about patents, that gives you more limited information, or I believe you can get the file history for, say, issued US patents. You can access through this tool called public pair. And that gives you, so you could go, remember I talked about a file history. Say you're in the process of doing research for your invention, you've done some prior art searching, and you found a patent that you think is very relevant, right? It's close to somehow relevant to what you're doing. Maybe you want to go take a look at the file history and see what that looked like. Or if you're a person who's trying to get an idea, how do I draft my specification? You can find one of those applications, find one of those patents, go look in public pair, and you can see what some of these papers look like, and it'll give you an opportunity to do that. So that can be another useful tool, just not even for your specific application, but just to give you, just to teach you generally give you more information, more knowledge about what these things look like. What does a file history look like? What does the missing parts look like? You can get all the specific things. So that's something, I guess, if you're going to start doing this, go to our website, search public payer, just put it in Google, public payer PTO, boom, it'll come up.
Yeah, and for those of you who are not really completely clear on what we're talking about, PAIR is an opportunity for you to set up a USPTO account, and it allows you to manage all of your activity that's associated with USPTO. So if you file a trademark and you're waiting on a response, you're able to look at it from there. You're able to receive emails in response to, if there's
and
an
it also
action.
you can also file your applications electronically, file your responses electronically, all of those things. You never have to submit anything, and we're encouraging that. There's a surcharge now to file an application in paper, right? Everyone files them electronically now. So if you bring us an application and give us a paper and an application in paper, say, here, file this, we're going to charge you a surcharge because we have to convert that now to an electronic format.
And the account is free, and you don't have to be submitting something right away. You can go ahead and set up your account today. And that way you can manage and navigate, and it also allows you to customize it as well. As far as resource information, you'd be able to put it in your particular file or account so that you are able to see everything.
Right, and that's very useful. I would certainly consider, urge you to do that. Here, we just want to touch again. I think we talked about the regions, what all the regions are, where we are. The headquarters is here in Alexandria. I moved to Detroit in 2019 I lived in DC and worked there for a long time, but I originally from Michigan, and I wanted to move here to be closer to family. So I had an opportunity, moved here to Detroit. We also have Denver, Silicon Valley, and Dallas, of course. This lists some additional resources. This Inventors Assistance Center, and some of these next few slides will go into this in a little more detail. We have pro bono programs. These are programs where services in drafting and preparing and filing applications are provided free of charge there are some set up that are done by law firms, some that are done by law schools. Excuse me. And
we'll be covering that in the next month sessions, because Washington University and St. Louis University offers pro bono services. Oh,
great. And some years ago, I don't remember, unfortunately, the professor's name. I wrote an application for someone at WashU, but I don't remember anymore who it was. Just interesting to me. Anyway, so we have the Inventors Assistance Center. Here are the hours, 8 to 8. This is going to be Eastern time. Call 1-800-PTO-9199. There's a lot. It's staffed by, these are former supervisors who have most of these are for folks who've retired, and then they come back and you can man these lines. So these are very experienced people.
Oh, I didn't know that.
Yeah, that's what a lot of these folks are who are answering these things. They're also, I believe, and I'm not entirely sure, but I believe we have people who do this on supervisors who do it sort of on a detail, on part-time basis too, to make sure these numbers are manned and there are people there always available. So I know folks who've retired who've come back and are doing this and answering questions. So there's really a lot of experience here. The people are really knowledgeable and they're really eager to help you. If you want to call that number, that is one to write down and keep an 800-786-9199. And, if you give them something, and they will be able to help direct you to where you need to be to get your answer. Trust me, I've got calls from them just out of the blue. I have someone who called about a re-exam. Can you answer the question? And they called me up. So it happens. So this is a little bit about the pro bono program, which Sherry said you're going to be talking about later. And then it's nice to hear that WashU is a part of. So this is a nationwide network. There are requirements for it as to these different things, attorneys, agents, and law firms, and how that's done. Visit uspto.gov, which is our main website, pro bono patents. If you just go to Google and put pro bono patents, PTO, it'll direct you to the website that way if you don't know the link. Here are a little more information about this by region. These, we don't, the patent office doesn't actually run these programs, but we can get you in touch with the folks who do. So there are 22 regions here, as we point out, across the country. and you can get to the right region. These are the patent trademark resource centers James mentioned. These are, we sometimes call these the patent libraries. These have access to information, and many of them have sites where you can actually go and use a computer to do searching and use the databases that we search to search patent databases and things like that. So that, and a lot of other information is available there. Folks aren't allowed in the office now, but you can come into our office here in Detroit. But
and for St. Louis, it's located at St. Louis City Library. And in speaking with Damien, the Midwest Regional Office Director,
yes,
that's a big deal, folks. In speaking with him a couple of weeks ago, there's now discussion about expanding that reach beyond the libraries and having certain, I don't know if academic institutions or organizations provide that service, so it's more accessible to you guys. So just be on the lookout for that. And this map is available on the USPTO website so that you can click on it and get the information you need about it.
Okay, thank you. This is the law school, this is one of the law school programs that we have.
Excuse me, Tim, to answer your question earlier, I believe the USPTO still sends out paper office actions, but most applicants are electing to get that electronically now.
That's what I thought. Thank you, Vivek.
Okay. Thank you.
There's still like an option. It's not a big percentage, but we still have.
Right.
I mean, I deal with a lot of attorneys. I know I did talk to one person at one law firm. Their law firm prefers to have paper office actions, but
sure.
But that's like a minority. So that's
I think, and we're more and more we're moving away from all of that. So, but yeah, thank you for the clarification. These are some other resources. I think James had put this up. This will be a valuable resource for you. It has, again, our helpline number. Then for some specific things, information on microentity status. For pro se, again, pro se simply means you're filing without the assistance of an attorney. And a bunch of other resources here. So I urge you again to go to, always start with uspto.gov. Go to uspto.gov. And at the top in the search, if you have a question about a specific topic, just put that in the search bar at the top and you will get resources. If you're unsure where to go, please call that 800 number and there will be people there available to help you and eager to help you and give you whatever assistance we can. So that brings us to the end of the slide presentation. So we have about 10 minutes left, right?
And so while we're gathering any questions for participants, like I said, I'm sitting on loads of questions. So I'm not here to dominate the question line, but I can keep them busy for 10 minutes. But I want you guys to formulate your own questions and you guys will jump the line so that you can get them answered. But I do want you to revisit the prior art, Tim, as far as we haven't mentioned that there's 12 months before you file for a provisional patent, a year before you file for a provisional patent or any type of IP that you have the liberty to talk about your idea. Did you want to touch upon that? And then also, I need you to be very clear about what your office does in conducting its research about prior art when you receive a utility patent. Basically, how are you able to identify that prior art existed, and it may be their own, so maybe they've disclosed it 2 years ago.
As far as searching go, we do computer searching by computer databases. We search inventor.
You need to hear that.
We search inventor names. You search companies. If you know a company is a big player in one of the things you search, you may use that. You search keywords for what, we have patent databases that we search. You have non-patent literature databases. If you have a chemical structure, you can do a structural search of what that chemical compound is. Part of the searching in the databases that you use will be dependent on the subject matter of the application you're looking at, right? So, some things, a lot of the new tech stuff, there's not a lot of old patent literature. Most of that stuff has been published in things that aren't patents, that are, magazines, our trade things, our stuff like that. So
University journals.
right, journals, exactly, lots of stuff like that. So we are looking for those now. That stuff's a lot more available than it used to be. If there's anyone else from the PTO who would like to add anything to that, please do. Either Patrick or Vivek or anyone else, please do anything about that.
Because I think a lot of the inventors don't realize that they can invalidate their own patents because they've been disclosing it 2 years prior to.
That's part of what I told you about, like the marketing research, that you have to be very careful because there's a public use, public disclosure, public sale can create a bar if it's more than 1 year prior to when you filed your application. Okay. So, and that happens sometimes. People don't realize there's a famous case where it's a guy invented something that was going to be used on a beach. It was a driving vehicle or something. He took somewhere at some point, took a picture of it. It was dated. Somehow he eventually filed his application. That picture somehow, I think it was later on.
There you go.
But he was trying to enforce it. Someone found that picture, and that was a public disclosure prior to 1 year prior to him, and his patent was invalidated. So which
means he can't file something on it, and another person can't do it.
Well,
either.
It's available as prior art. It can be used against prior.
Exactly.
There's a slight distinction between prior art and an on-sale bar. An on-sale bar is a very specific thing, and it goes to the actions you took. Okay. If you disclosed your invention, if you did those things, it doesn't apply so much to other people, right? It depends what it is. If you publish a paper, right, more than a year before it, that would apply to everyone. Anyone else, that's available as prior art to everyone. But there are other instances, which we call on-sale bars or public disclosures, where you may, for instance, go to a conference, right? And you present information about your invention, and it's more, and maybe you do a presentation, or you hand out flyers. That disclosure can be used against you as a public disclosure if it's more than 1 year prior to your filing date. And that happens. There's a whole case law developed about that, about what constitutes a public disclosure. So you need to be very careful about it. That's the importance of filing the provisional application and then following that up with the non-provisional application 1 year later.
Could you set the record straight on filing a utility patent on mobile apps?
Okay, what do you mean by that? Set the record straight.
Because there's been some discussion that you cannot file a utility patent on apps, that you have to file a copyright, or
Okay, all right. So this is the way we refer to. You don't file a patent, you file a patent application, right?
There you go.
You can't file a utility patent application, right? The application becomes a patent down the road if we want, right? So
gotcha.
Now, what you're talking about, I think what you're talking about is this issue of statutory subject matter. And you're talking about specifically for software, is that what you said? Or for
yeah, it just, whenever
apps.
A lot of students, of course now in this climate, a lot of students are, and I shouldn't just say students, just inventors, are developing apps and are hearing that they cannot file a patent,
so this is
utility patent on an app.
Well, okay, wait. You can file the application. You can file whatever you want to file. You may have a statutory problem. You may run up against a bar, and that may be this issue I talked to you about, what is statutory subject matter and what is not, right? There's some things for which we will not give you a patent. Those are abstract ideas, mathematical expressions, and what we're calling certain methods of organizing human behavior, right?
Right.
These sorts of apps, how do I go on Facebook? How do I go on a dating app and match people up?
But that's a process. It's a method and a process.
But all processes are not patentable. That's the point.
Ah, that's why I need to hear.
Right? And that's why you need it. That, though, gets into a much more in-depth discussion about statutory subject matter, about the history of statutory subject matter, and about what is and is not statutory subject matter. Basically, if you claim something like that can be a method that could also be done using paper and pencil by hand, you may not be able to have, that may not be patentable subject matter. As to these things about how to navigate an app and use it, do all these things, unless you add something in the claim that results in an improvement in the processing of that computer or the use of that, you probably cannot have a patent. So this is actually a very active point in patent law right now. There are cases that have been decided recently by the Supreme Court about it. There is a lot of discussion and people with very strong opinions on both sides about it. But this statutory subject matter as to things like these apps and how we do these things is very much at the forefront of patent law right now. So I would say that about that.
Okay, and then could you clarify, what are your thoughts about how to differentiate between what's an improvement and what's and when it borders infringement?
Well, I mean, those are separate questions, right? An improvement is some, you know, is, well, you make an improvement. That is what it is. Whether or not that results in infringement it depends on a number of things. One is, what are the claims of that patent, right? Someone will have a patent, it'll cover a certain amount of subject matter, right? And you're going to have something. Now, what I hear you saying is you've done something a little different. You've made an improvement. So you've added on to that, right? So their patent might expressly say everything about your invention except that one, what you're calling the improvement, right?
Right. So that's
right?
an addition.
Right. So now when you come to me at the patent office, I may say, you know what, that's enough of an addition that it's not obvious in view of the prior art. You can have a patent, right? And you can go have your patent. But then you have your patent and now you go to enforce your patent. And the other person who has the broader claim, which covers your claim, may say, not so fast. You're infringing my patent, right? And they may bring you into court. Well, then we really get into the specifics of, and it's all fact specific. What exactly does their patent cover? What exactly is the nature of your improvement? And whether or not it's going to be covered, that's a whole nother issue called the doctrine of equivalence that we look at under for infringement purposes. That's really beyond the scope of what we do at the patent office.
Okay.
And evaluating patents for that purpose isn't really something we do as examiners, right? We just look at that first chunk, the procurement part. Once the patent's out the door and you're enforcing it, there's a whole other set of case law that's developed around that. That's relevant to that. So you have an opportunity to defend yourself, to say, you know what, you could say a number of things. You could say, you know what, their patent's not even valid because here's prior art, teaches their patent, and they shouldn't have had that in the first place anyway. You could say it's unenforceable. They engaged in some sort of inequitable conduct, and so that patent would be unenforceable. Or you could come up with an argument, you know what, we don't infringe that patent, and here's why. And you can, so there's a whole process for that once that unfolds.
My final question would be the same type of comparison between a design and utility patent. We know that a utility patent is based upon the function, and design is based upon how something looks. Let's use a cell phone case as an example. So if you have a cell phone case, which all looks the same, but you add a feature which adds a new function. Do you file a design patent because you added a sleeve or a pocket to the case? Or did you add a new utility where you have to file a utility patent?
Well, maybe you file both.
You can, but do you need the utility patent?
Well, again, that would again be a very highly fact-specific question.
I see. Okay.
You know what I mean? You may or may not. That's where you get into, you either get yourself a lawyer or you read a whole bunch about patent law and you figure out what you need to do, right?
Gotcha.
Because that's not a question that's just that's very fact specific, right? It's a very fact specific sort of inquiry. But you do need, that's very important. You do need to think about those things.
Okay, excellent. Well, Tim, thank you so much for your participation and for leading
Thank you for the opportunity.
Excellent. And for those of you who are participating, just know that we have a major event this Friday with Stephen Key, the licensing king, to provide you with information, anything and everything you need to know about how to license your product and get it off the ground. So make sure that you register on Eventbrite, in addition to Inventors Association of St. Louis website under our calendar. So with that said, thank you all for coming. You guys have a great evening.
Have a great evening, everyone. Thank you again for the opportunity.
I just want to say thank you. I dropped in our chat. You can visit our website, Scandalaria Center's website, and we have an event coming up. So our next event coming up is to learn the key to licensing success and the freelance bootcamp event. That's on January 20th. And also, I just wanted to say thank you to all those that attended this. It was a great time hearing all what Tim
And the
went-
video, this video recording will be on your YouTube page.
Yep, it'll be on our YouTube page. And I want to say, Patrick, thank you for the amazing things that you were posting in the chat. Really appreciate it. And
Thank you,
thanks to
Patrick.
everyone.
Yes, Patrick, thank you.
Okay,
right.
well, you guys have